Michelle, are we recording?
Okay. Yep.
Okay, perfect. Great. Thank you. Great. Well, welcome everyone. Today, we are for Vermont MTSS office hours. We will be focusing on hazing, harassment, bullying, Rule 4500, and exclusionary discipline. Those are really broad topics, so we'll do our best to give you a broad overview of the way in which VTmtss engages with the forms and our processes when we're hearing from the field and from families regarding these three topics. Myself, I'm Jay Jared, she, her pronouns, VTmtss team, and I'm here co-presenting with my colleague, Tom Ferris.
Hi, I'm Tom Ferris, also the Vermont MTSS team, he, him pronouns.
Wonderful. So we like to anchor our presentations with our belief statement. So I'll give folks a few moments to read the VTmtss belief statement, which should be located on your screen. And we're going to move forward. So the focus for our conversation today, our objective is for the VTmtss team, Tom and myself as representatives of that team, to share information, connect with the field, and address questions related to a specified topic area. So our agenda today, we will briefly go over rules, regulations, and guidelines that are underpinnings of hazing, harassment, bullying, Rule 4500, and exclusionary discipline. We'll briefly touch upon the conditions of reporting for each of those topical areas. We'll do a quick forms review and make mention of the information that we and our, as part of the VTmtss team receives. And then briefly overview what our process is when we receive information on these topical areas and what our response approach is, just to help you peek behind the curtain to see what our back-end approach is to support the field, families, and our educational communities. So first, we're going to begin very briefly with harassment, hazing, and bullying, also known as HHB. The legislative underpinnings of HHB prevention work comes from Title 16 Education, Chapter 9, and subchapter 5 for harassment, hazing, and bullying. And in essence, this is indicating that each district shall address all complaints of harassment, hazing, and bullying according to the procedures accompanying with the policy, and that the AOE provides a model policy, which serves as a baseline for every school entity to utilize. It is a baseline. You could certainly add more into the model policy, but you certainly could not detract anything from it. And so the policy is really the anchor and the work of establishing what the definitions of harassment, hazing, and bullying, what the determination process might be, should an investigation move forward, what the investigation process looks like, and to fruition, and then the independent review and internal review processes afterwards if there is a concern or a grievance. So in terms of our interactions, I am the point person, an HHB coordinator in the Agency of Education, and so my role is two-pronged. One, I facilitate our internal HHB prevention work group, which is focused on helping to update the model policy and procedures, identify some preventative guidance and resources to help support the field, and bringing in other folks who can serve as content experts in helping us to elevate and advance this work moving forward. The other prong of my role is occasionally I will receive inquiries from families who may have questions or concerns about the HHB policy or the process and the way that it was enacted in a school or a district. So we have we being the VTmtss team has a harassment, hazing, and bullying prevention help request form that is utilized from often families and caregivers as an entry point for them to share their concern or their question about the policy and process. School officials at the end of the year do complete HHB information through CSRS, the Crisis Incident Report form. And again, that's at the end of the year, but our team doesn't necessarily see that information. So when we are receiving information about HHB, it's largely anecdotal. It's very microscopic in terms of what might be showing up within the school landscape of HHB, and it's often an entry point to get information from the family, help to inform, and also to connect with the school to see how we could be supportive in a variety of different circumstances that show up. And so briefly, just to give you a sense of the flow, when we do receive a request form, sometimes it's not necessarily the request form that's the entry point, but a phone call or an email to the AOE, and it gets channeled to me. So we review that information. We receive contact information as well as get a sense of what steps the person who's completing the form knows about and has been engaged in the process. So have they received communication? What is their sense of what is showing up and what are they seeking support for? I'll reach out to them to see if there's any additional clarification that's needed. But once I receive information, I will reach out to the school personnel. I may have had some conversations with some of those on the call today. And our approach is very compassionate, it's restorative and relational based. And so my role is not to mediate, but to really compassionately reconnect the family and the school officials if needed, and also to help offer support if there is an appropriate reason or a mechanism that I may be able to. In those meetings with school officials, we tend to co-create what that next step might be, and what a next step could look like would be to send for me to send some preventative resources that I'm learning, nationally and from different organizations or from the U.S. Department of Education. It might be just to let them know if I hear from the family again, and again, really trying to reconnect in a compassionate and productive way, knowing that everyone, though there's a myriad of emotion that comes through with an HHB request or inquiry or concern, that we're all really centered at the students' well-being and hoping that empathy can be threaded throughout that. And then there's follow-up as and communication as needed as well. So that's a little bit of insight as we are evolving our process when we're receiving information about and concerns primarily from families on HHB.
Thanks, MJ. I'm going to take it from here, talking first about restraint and seclusion, and the information or the procedures and reporting around restraint and seclusion are governed by State Board of Education Rule 4500. That's been in place for, I think, the better part of 20 years, certainly more than 15 years. I'm hoping that everybody who's here on the call today has some familiarity with this, because this is unlike the work that MJ was just talking about, which is something we've undertaken as a way to respond to concerns brought to us typically by family members in the community. This is a required set of procedures and reporting requirements. And today we're going to be really talking largely about the reporting requirements and how we respond to the reports that we get. When you're reporting an incident of restraint or seclusion to the AOE, there's an online form. And we have just recently updated that form. There's a link connected here, but you should be able to access it directly from the AOE webpage. It's important to keep in mind that if you are reporting, to use the updated form. The older form will not feed the database that we're using, and we would have to request that you resubmit the form, which is something I hate to do. We just don't want to create extra work for you. So we're just trying to get the word out. If you have the old form bookmarked, if you're accessing it some other way than through the web page, please go back and change that and use the updated form. There are 3 reasons why you would need to report an incident of restraint or seclusion to the agency. And those are if the restraint or seclusion have been used for more than 30 minutes, if there's been death or injury, an injury requiring an outside medical attention, or if the restraint and seclusion have been used in violation of the rules. And we'll get into a little bit more detail about that when we talk about follow-up. The most common report that we get, and that's not mentioned here, are restraints or seclusions lasting over 30 minutes. These are, I would hesitate to say what percent of what we get, but they are the most frequent. And although it's not something that we would necessarily want to be seeing, it doesn't necessarily result in any follow-up on our part unless there's something else in the report that catches our eye where we feel like maybe we have some additional questions about what went on. We also have reports of injury, fortunately not death, but we do have occasional injury reports. And most of the injury reports, far and away, the most common injury reports are injuries to staff, but those do need to be reported as well. We may follow up on some of those. That would typically be just a check-in to see how folks are doing. Is everything okay? Is there any way that we could offer some support that might help prevent future injury? But that's not typically a violation. That's more just a check-in. The most common violations that we check in are actions taken by untrained staff and or incorrect or inappropriate use of restraint and seclusion. When we have one of those, we will follow up, or if we suspect that that's the case. And we typically do that through a virtual meeting. We review the incident. Most often we'll have the school principal, often the superintendent, often another staff member, perhaps a behavior interventionist or somebody who has more specific knowledge of the incident that took place. And the first thing is to determine whether a violation took place. It's not always clear. The rules are pretty lengthy. Those of you who are familiar with Rule 4500 know it's a many-page document with a lot of conditions in it. And sometimes it takes some review and discussion to determine whether a violation did in fact take place. If we do find that there has been a violation, then we have some discussion about what is currently in place in the school and district that would prevent future violations. I will say that by and large, these are discussions where we're gratified to find that the district already has a pretty extensive process in place and that they are making really good efforts to ensure that staff are well trained, to ensure that in the unfortunate case that restraint or seclusion does need to be used, that it's done appropriately and to the minimal extent necessary. it's extremely unusual for us to be in a situation where we feel that we need to have continuing technical assistance or any other sort of response to the situation. However, if there is a violation, regardless of those conditions, we do have to draft a letter which documents our findings, and that's provided to the superintendent, who is then required to keep that on file. If there were a situation where we felt that the restraint or seclusion violation was a result of inadequate training or failure to maintain appropriate staffing, that might be a case where we would have some further discussion about what the agency could do to provide additional resources. The next area that I'm talking about is exclusionary discipline, and it should be noted that this is specific to students in kindergarten to age 8. This relates to legislative action that took place a few years ago, Act 35, which prohibited the suspension or expulsion of students under age 8 unless there is an imminent threat of harm or danger to others. We use the language that we already had through Rule 4500 to help firm up that definition of imminent threat of harm. And what we were left with was a legislative requirement around this, but no other real information about what to do with that other than to disseminate that to the field, which we have done. The agency made a decision that it would be in everyone's best interest if we began data collection right away to determine the frequency of this, the causes for it, to get whatever data that we could surrounding exclusion of students in kindergarten to age 8. This is an anticipation that the legislature will probably resume looking at this again, having put this into law. So we felt it'd be best to be prepared with the best data that we could collect in order to further guide whatever decisions they make about this. This is also reported using an online form, which is available through the website. So we're grateful that many of you are reporting this. There are some schools we know that are very diligent about making these reports, about contacting us with questions about this. We do have a concern that there may be an underreporting. There's no way for us to know. But given that there are some districts for whom we never receive a report, we just don't know what's going on. So we're hoping that people do become more aware that this is an expectation, that this is something that was put out as a requirement by Secretary French 2 years ago, and that expectation is still in force. In terms of follow-up on these reports, we review the reports when they come in. The data is recorded. It's not typical for us to have any further follow-up. Usually we just record this and this goes in the database, and this is for informational purposes when and if the legislature does resume discussion about this. In some instances, if the suspension doesn't seem to meet the legal requirements, if it seems pretty clear from the write-up that there was no apparent imminent threat, we're likely to follow up with the school just to explore that a little further and to give a gentle reminder that that is what the legislature did intend when they passed the law. We also may do that if the suspension is imposed for more than one school day, because that, depending on circumstances, might suggest that there is something more than just the response to that imminent threat. This just involves a discussion of the incident and how the requirements of Act 35 are being considered and implemented. There is no provision in the follow-up for any sort of determination of violation or further action on our part. So we are now at our question and answer section. We'd like to just open the floor for people to ask questions or get further information about any of the information we've presented.
Shelley, I see your hand up.
Hi there. Thanks, Megan. I have a question in regards to, I think I know the answer, but I just want to verify, maybe from Thomas, around 4,500 and student escorts or transports. Our district has recently switched restraint, state approved restraint modalities. And in an instance where a student does not move on their own and they are escorted, is it AOE's position, because it kind of is my position, that anytime hands are put on a student and they are not moving of their own volition, that would be an appropriate use, that would be an appropriate time to fill out a 4,500. As you can imagine, sometimes when training staff, there's a little bit of hair splitting around, well, it wasn't a restraint, it was an escort.
Mhm.
Just wondering about your thoughts on that.
Yeah, I would agree with you completely that the guideline is that if the student is not moving willingly, that would be considered a restraint if you're moving the student against their will.
Right.
Admittedly, that's sometimes a little difficult to judge. You know,
Mhm.
if they're saying I don't want to go, but